Hello, I'm Mark Beyer, Senior Editor of Business News. Welcome to the first episode of our Legally Speaking webinar series for 2026 with Pragma Lawyers. I'm joined today by Director Elizabeth McLean and Special Counsel Matt Micale. Welcome, how are you going?
Well, Mark, how are you?
Thanks, Mark. Nice to see you again.
Great to see you. Okay. Now look, the legal and commercial environment, it's constantly changing. So in light of that, it's really important to stay across legal developments. It's really critical for safeguarding your business, and that's really what we talk about today, to give you an update on some important legal trends. And today, the broad topic is restraints of trade, which you might think of as the fine print that protects your business. So Elizabeth, could you just give us a run through about what's on the agenda for today? What are some of the key topics?
Yeah, sure, Mark. So an ever important topic for any business owner and one that has received a fair bit of media attention recently with discussion about potential amendments to the laws around restraints of trade. For the moment, restraints of trade are very much lawful and something that employers and business owners use. They are something that prevents people from engaging in certain trade activities, including doing work for certain clients, poaching staff, poaching clients, or even acting in competition after a business relationship or an employment relationship ends. So we'll talk through how restraints of trade tend to apply in the employment context. A couple of cases, one where the restraint was enforced, and that's usually enforced through an injunction in the Supreme Court, which is quite a serious remedy, and an example where the restraint was not enforced. And then Matt will talk through some examples of restraints in the shareholder context, and we'll finish up with a discussion about what's happening next, what's on the horizon for the law of restraints.
Okay. Well, look forward to that discussion about cases that were successful and those that weren't. So Matt, just dive into some of the detail here about restraints of trade generally.
Absolutely, Mark. So it's probably a buzzword that a lot of the viewers have actually heard of, but I think it's probably a little bit misunderstood about how restraints actually work in practice. So what we're talking about generally is a contractual mechanism put in place between a party and a counterparty to prevent action. And as Libby had mentioned, it's usually in the context of accessing confidential client information, or it might be to do with actual relations with clients and data lists.
So in that regard then, so is protecting confidential information treated differently from protecting client relationships?
Yeah, it certainly is, Mark, and that's a really good question. So at law in Australia, we have a general position, which is restraint clauses are generally unenforceable and they will be considered to be void, subject to certain criteria being met. The first criteria is we need a legitimate business interest that attaches to the restraint. Legitimate business interests are grouped into two fairly standard bundles. The first is confidential information, trade secrets, all the know-how and sensitive intellectual property that a company or a business might actually retain, and that's where the value is. It's quite easily identifiable. So on that basis, a court will typically allow confidential information restraint clauses to be more broadly drafted. If we then move to the client relationship aspect, that's an intangible. It's a little bit more difficult to crystallise. So that goodwill component typically results in courts applying a far more narrow lens on restraint clauses. However, provided you can satisfy your restraint clause applies to a legitimate business interest in the first instance, and then secondly, that you've got a narrow and clearly confined or reasonable scope attaching to your restraint, and that usually applies to the duration, it applies to the area, and it applies to the purpose. If you can satisfy those two criteria, then the courts, as Libby mentioned, they will allow restraint clauses to apply at law.
Okay. I look forward to getting into that detail because a lot of people might work for an established business and then at some point they'll think, I'd like to go out and set up my own business, which inevitably means competing with the old employer.
Correct.
So it'd be great to get into the detail about when it's, I guess, safe for that person to do so, without breaching these laws. So Libby, let's get into some of those practical issues then with enforceability.
Yeah, so restraints can be difficult to enforce. There is a presumption in Australia that they are void. So the party seeking to enforce the restraint has to convince a court that it shouldn't be assumed to be void and should be enforced. And as Matt says, that will only happen if it can be demonstrated to be reasonable in terms of its extent, its scope, the way it's tailored to the particular situation. Now, the issue with enforceability, it plays out differently in different states of Australia, interestingly. New South Wales has its own legislation which governs restraints. So the courts take a slightly different approach in New South Wales. They can actually read down restraint clauses to bolster the chances of them being enforceable, whereas in other states, the only option is to sever parts that are deemed unreasonable and unnecessary so that other parts that remain can be enforced. Not always will those other parts make sense and be enforceable. And it's a common trap for businesses who've drafted these clauses to assume that if they have lots of different levels within the restraint, so for example, that might be levels of geographical reach, so Perth, Western Australia, Australia, the world, levels of time periods, so 24 months, 18 months, 6 months, 3 months. Businesses will often assume that if they've got a cascading clause like that, it will be enforced to some extent, not necessarily the case. So what happens in courts in states other than New South Wales is the court applies a common law test called the blue pencil approach, and that's where they will identify, if possible, an element or a variation or aspect of the restraint that is reasonable, be that 6 months within, for example, 5 kilometres of the employer's business premises, and it will blue circle that and say, this one's okay, we'll enforce it to this extent only. Now, the drafting tip there is ensure that each of those different variations are enforceable in their own right, because if by virtue of severing, say, the higher geographical area, the clause no longer made sense, or the contract was fundamentally changed when that amendment was made by the court, the whole thing will fall over and you won't be able to enforce anything.
Okay. Is it fair to say as well that the interpretation of this depends on the market in which you're operating? So if you've got a business in suburban Perth, the market would be seen differently compared to, say, in a small provincial town.
Yes, absolutely, Mark. And that comes back to the importance of tailoring each restraint to the particular business, the activities that business conducts, and the particular employee. So if you had a restraint that purported to restrain an employee from working in any competing business in the world, and you only operated in a small part of Western Australia, there's no way a court is going to enforce that restraint.
Okay. So there's these two different approaches then, are there? There's the blue pencil approach and then also the cascading clauses?
Yeah, so the blue pencil approach is an approach that courts will take in states other than New South Wales to those clauses that tend to be cascading, and that's the step-down approach in terms of geography and time periods. So it's absolutely vital to ensure that whilst cascading is still the highest likelihood of having part of it enforced, that it is still tailored to that particular person. So what we commonly see is an employer has gone to a lawyer and has got a really robust restraint clause. It's cascading from 18 months down to 3 months. It applies in Perth, Western Australia, cascading areas, and they apply it to everyone in their business. They use the same contract template and they apply it to everyone from the intern up to the CEO. That's not going to work because it's just not fair to restrain the intern from working in a competing business. Courts are very reluctant to prevent people from earning a living. So the drafting of the clause and the tailoring it to the particular employee and where they work is critical. It may be that they are based, for example, in WA, but they are a sales manager and they conduct sales in Queensland and South Australia as well. That particular restraint clause should be tailored so that it covers Queensland, South Australia and Western Australia, and no more than that, because that's where that particular employee is exercising his or her customer connections and is maybe the face of the business in those states, and that is recognised as a legitimate interest for the business to protect, being those client connections. If that person is the face of the business in those states, then the business is to an extent vulnerable to that person because all of their customers know that person as the face of the business. If that person leaves and starts a competing business, starts trying to compete in those states, the former employer will want to be able to enforce a restraint.
Okay. So when we think about what employers should be doing to protect their confidential information and their customer connections, the way you talk about it there, it's almost like they need to go through each different category of employee in their business. Now that sounds like a really exhaustive process. Is that realistic? What's a pragmatic approach?
Good question, Mark. And it is understandably a large task to go through every individual in your business. So I'd be urging employers to consider, do they need a restraint for their lower level employees? It might be put in there completely unenforceable and unnecessary. I'd be focusing on your employees who create a risk to your business. Now they tend to be your senior employees. They're often your business development managers, your sales managers, your estate manager, anyone who is the face of the business, has access to confidential information and owns or manages those client connections. They're the people who are a risk when they leave. They're the people who should have a tailored restraint. It's better to have a tailored restraint for the people who are a risk than to have a general restraint for everyone in your business that you've used from a template employment contract.
Okay. Now, is there some cases we can talk about here, lead into that, so I guess give listeners a bit more detail about, well, what exactly is going to work and what won't?
Yep, absolutely. So there was a case just last year in the federal court, the case of Lamson Concepts Proprietary Limited and Schmidt. Mr. Schmidt had been an employee of the business for a very long time. So he was a long-standing employee, very senior. He had been in the position of business development manager. Soon before his employment ended, he was actually promoted to team leader. Now, it's a bit contentious around the promotion to team leader, and it becomes critical because it's in the contract he's given when he becomes team leader that the restraint clause is located. Prior to that, he didn't have a restraint clause. So Mr. Schmidt is given his new contract for his promotion to team leader. He's given a pay rise. He says, when it all played out in court, I never signed that contract. Lamson Concepts said, well, you enjoyed the benefit of the pay rise. You acted as team leader. We treated you as team leader. It's immaterial that you didn't sign the contract. By your conduct, you agreed to that contract. So this all played out in court because the relationship eventually broke down between Lamson Concepts and Mr. Schmidt, and he eventually went out and started trying to compete with his old employer. They found out because he tendered for some work that they were also tendering for via his new business. They sought to enforce their restraint. Ultimately, the court ruled in their favour, an injunction was granted, and the restraint was enforced. Now, the key reasons why in this case was Mr. Schmidt had a lot of access to confidential information. It was found that 12 months was a reasonable time in order for Lamson Concepts to find somebody to replace Mr. Schmidt and build up their own relationships with the customers. So basically minimise the loss that would come from Mr. Schmidt leaving the business. So 12 months was deemed to be a reasonable time for that replacement to build that rapport with their customers and take over.
So if he waited 12 months to go out and set up the new business, he would have been okay?
Likely so, yes. Yep. Because the courts will, when assessing what's reasonable, they will look at how long will it take to find a suitable replacement? How long will it take for that replacement to upskill enough to serve in that role, promote the business's interests, form those customer relationships? In this case, it was deemed to be 12 months. Had it been deemed to be a longer period and had the restraint had a longer period in there, potentially it could have been enforced for longer, and courts have enforced restraints for up to 2 years. It's rare though.
Okay. And that presumably, the longer the restraint, that would be a more senior, influential person.
Correct, yep. So somebody very senior, very influential, very much the face of the business, and high access to confidential information, owns the client connections, very influential. So in the case of Mr. Schmidt, 12 months was deemed to be the reasonable period. And another point I should make about that restraint was it was limited to the states where he did work. So it was tailored to what he did, and it was reasonable to restrain him in those states because that's where he'd worked for Lamson. That's where he had client connections.
Okay. And then you've got another case where the restraint was not enforced. So what was the situation there?
Yes. So these matters are always case by case, Mark. So never assume that your restraint will be enforceable. Get advice before you implement it. The court's going to look at what was the situation of the parties, what was agreed, and what was reasonable at the time the contract was entered into. So not at the time it's sought to be enforced. So in a contrasting case, Avant Group and Kittle, the restraint prevented the employer from working for a competing business, canvassing or soliciting any person that was at any time an existing client. Interestingly, the employer's business that was sought to be protected was Avant Group as a whole. So it wasn't just the part of Avant Group that Ms. Kittle worked for, but it was the whole group. Now, the problem with that is the group did lots of different things. So it wasn't reasonable to restrain Ms. Kittle from doing any type of work that could possibly compete with any of Avant's different businesses. What would have been more reasonable and more enforceable would have been if she was restrained from doing competing work with the subsidiary business that she worked in. So it was ultimately deemed to be too wide in its operation. Also, in terms of the non-solicitation part of the clause, it had unlimited scope in that it defined a client as any client of the business. So that's potentially any client of the business since the business existed. Whereas a better way to do it is to define a client as a client of the business within, for example, the last 12 months of that person's employment or who that person has dealt with in the last 12 months of their employment, limit it to that particular person as opposed to any client that has ever been a client of the business. So that was another lesson learned by Avant when they were unable to enforce that restraint.
Okay. Oh, look, those two examples, I think they really help to sort of cut through the general issue and focus on what's really what counts. So, Matt, I guess the other side of this is restraint clauses in shareholder agreements.
Yep,
so
absolutely.
Can you run through that?
So I think in the commercial sense, and whether that's in share sale agreements, whether that's business sale agreements, whether that's shareholders agreements, these concepts that Libby has already flagged can continue to come to the fore, and they are all based on that standard criteria of enforceability will be determined on a case-by-case basis based on whether we can satisfy our primary criteria of establishing a legitimate business interest that is needing to be protected, and obviously that the scope, the purpose, the ambit of our restraint is appropriate. So in a shareholders agreement, we obviously have access to the internal organism that is a company. And with that comes a substantial amount of trade knowledge and secret that carries material value for companies. That is where the significance of the restraint clauses in the context of shareholders agreements arise. So we can broadly group restraint clauses for the purposes of shareholders agreements into, let's say, 3 buckets. We've got our non-solicitation or non-poaching clauses. They obviously protect the ability for a company to protect the clientele that business or company has developed. And as Libby has pointed out, there's an overlap that typically exists between shareholders who are employers who have the ownership of those relationships. And where that is the case, that is an inherent issue that needs to be dealt with. We also have the more commonly known confidential information non-disclosure that in itself carries probably the most weight, and that's the most recognised restraint because, as we said probably about 10 minutes ago, that bucket of legitimate interest is the most broadly and widely accepted by courts. We then also have our other third bucket, which would probably be our non-compete. And funnily enough, the majority of the cases that I'll speak to deal with this issue of transitioning shareholders who happen to be employees trying to siphon off clientele from one place to the other. naturally ownership of clientele, the material and the business goodwill that attaches to those, that carries substantial value as well. So really what we're seeking to achieve in a shareholders agreement when we're putting in place a restraint clause is to prevent that direct competition with the company. We're seeking to prevent the disclosure of confidential material and information. We want to maintain all of our trade secrets and our knowledge that we spend time investing in and developing. And we want to make sure that counterparties who are leaving a company or leaving an employment sphere are not then seeking to detrimentally affect or tarnish the reputation that came with that counterparty business originally.
So Matt, when a company is drafting, should the businesses be thinking about restraints in employment contracts and shareholder agreements together, or should they look at them separately?
Great question, Mark. And I think the answer is to not be too evasive. It's a case-by-case scenario, but we need to align purpose between the shareholders agreement and the employment contracts, but the scope needs to be tailored. As Libby has mentioned, the courts will apply different tests to the agreements as they come. So the employment agreements will be more favourably assessed in terms of an employee. There is the presumption that a person is entitled to go and earn a living. Shareholders agreements, you're an investor in the capital of a company. Those agreements and those clauses tend to be more rigorously assessed. So we'll look at some case examples perhaps to show the interplay between the employment and the shareholders agreement sphere and when these clauses will and won't work. So our case example of when these clauses will work, we'll start with a case of 2021 in the New South Wales Court of Appeal of AGA versus Defined Real Estate Concord. Now, in this particular case, our focus person is Mr. AGA, who was engaged both as an employee of the company and a senior employee as a real estate agent and as an equity holder, as a shareholder in this company. Now, what happened as a factual position was that over a period of time, AGA had been poached by Bell Property. He was being courted, he was deciding what to do. To try and have his cake and eat it too, he, over a course of a period of time, proceeded to move or siphon client details and contact lists out of Divine Real Estate and into his personal accounts to then transfer across to Bell Property. As an engaged party from an employee perspective and a shareholder perspective, he was bound by an employment agreement and a shareholders agreement. The shareholders agreement is the one that we'll focus on though. That shareholders agreement put in place a restraint period of 3 years and applied to a geographical location of 10 postcodes that Divine Real Estate typically operated in. Now, the interplay between the relationship of the employment agreement and the shareholders agreement, to go to your question, is that the clauses contained in each of those documents were inconsistent, but the purpose, they aligned. So the scope might have been tailored differently, but the purpose was identical. So on first instance and then also on appeal, it was found in this particular scenario that Divine Real Estate Concord had established a legitimate business interest in maintaining the control of that client relationship and all of those relationships that Mr. AGA had tried to siphon off. So the court here upheld the validity of the restraint provision, and Mr. AGA was injuncted from doing as he had tried to do. Now, a little interesting tidbit on the side here, or two if I may. Mr. AGA was actually struck off the practitioner role for real estate agents for a period of 1 year after this. So this had a material impact on his ability to actually earn his living as an employee and practice at Bell Property by virtue of the fact that he had engaged in conduct unbecoming effectively. There was another party that was relevant to this case, and so Mr. AGA is our target person, but we had another employee and shareholder in this instance called Mr. Coombe. Divine Property tried to run the exact same argument, the same types of documents were in play. Different outcome applied. Divine Property couldn't find a signed copy of an employment agreement or a shareholders agreement from Mr. Coombe. That was detrimental. That was fatal to the argument that Divine Real Estate was seeking to run. And the court held, if you do not have the material evidence to substantiate your clause, conversely to the performance by conduct or acceptance by conduct principle that Libby was raising, in this instance, case by case, that was struck out. So that's when it will work and somehow won't work in the same context. Now, the standard unenforceable example, there's probably 1,000,001 examples that we could use from a case point of view for an illustration purpose, but we'll use the case of second chapter proprietary limited versus Sealy. Similar concepts flying around here. We've got two shareholders, employees. In this instance, we're dealing with wealth management companies. Those two participants are parties to employment contracts, shareholders agreements, share sale agreements, considering they sold their equity share, and management deeds. So we're talking about senior employees and we're talking about equity owners in the company. As is often the case, the two individuals decide, I want to go and work for a competitor. I sell my shares, I go off and work for a competing wealth management company. Escala Partners, as the aggrieved party in this instance, sought to enforce their restraint clauses under the shareholders agreement. This particular restraint clause had a period of 2 years, but it had a restraint area of the entire geographical location that Escala Partners proposed to practice. Now, notwithstanding that these were two senior employees who happened to be shareholders, the court, in this instance it was the Victorian Supreme Court, took one look at this clause and talking about unlimited jurisdiction or unlimited scope, they took one look at a blanket restraint and said, that can't apply. The problem with this clause in its entirety was there was no cascading provisions. So there was no ability for the court to read the clause down. So the clause in its entirety was severed. Now what that meant was...
So what effectively the firm was saying, you can't practice anywhere.
Correct. So it's basically getting to a position where if you want to truly make these restraint clauses work for your purpose, you need to tailor them. You cannot apply blanket. Notwithstanding that blankets will more likely apply for senior staff. As Libby had mentioned, if you're seeking to put a restraint in place in favour of an intern over the entire client base that a company might have, that's never going to work. So it really does require some careful thinking about how you want to apply your clause and who you're applying it to.
Okay. Which I guess, when it's a real estate agent, it's relatively easy for them to define the postcodes where they operate.
Correct, exactly
If
right.
it's a wealth management firm, it's tougher to do that.
Your scope is a little bit more difficult to define clearly, but as Libby had mentioned, what the clause should have done was more clearly define who these parties were actually engaging with. So set up your restrained purpose, in this instance, if it's a client base, to be clients that these two participants had dealt with over the course of 12 or 24 months. Don't make it an indefinite scope of clients, more than half or potentially more of which would have never been within the remit of these two employees or shareholders. So you need to carefully assess who you're dealing with, where they sit in terms of the organisational structure of your business, and then target the clause for that purpose.
Okay. Rightio. Well, there's a lot there for listeners to think about and absorb. And then just to make it a little bit more tricky, Elizabeth, the federal government has flagged some potential changes in this area that could widen the scope. So I think this came up last year at the time of the federal election. Labor government was re-elected. What are they talking about doing and where have we got to with all of that?
There was a lot of hysteria about it all, Mark. Headlines like restraint of trade clauses to be banned. It's not going to be the case. What is likely going to happen is that it will be unlawful to impose a non-compete, which is you can't work for a competing business, as opposed to you can't solicit our clients and our staff. So you can't work for any competing business business that competes with ours for an employee earning under what we call the high income threshold. So that's around $183,000 a year. And the policy reasons behind that are that particularly more junior employees are in an unequal bargaining position and they shouldn't be restrained from earning a living when they leave their job. The idea is that it restricts job mobility and productivity and wage growth, and that people should be free to move around and seek better terms and conditions of employment and not be restrained from doing so because of a non-compete. So we'll potentially see that in 2027 at the earliest, I'd say. There was a lot of discussion about it, but it's been shelved for the moment. But I would be cautioning employers to be ready for the change, review your employment contracts. Again, consider, do you need a restraint for everybody? For the people who you do need a restraint for, is it appropriately tailored? Because it's likely going to be the case that for people who it's not reasonable to restrain, that restraint clause won't be enforceable anyway. So there's no point having it in there.
So that income threshold, 183,000.
On that, yep, indexed each year.
So effectively it means senior management, perhaps people in professions it's more likely to apply to, but I guess for the vast majority of businesses and their employees, it just simply won't apply.
That's right. I mean, it's most likely that non-solicitations and non-poach restraints will still be lawful. So you can still protect your client connections by restraining your former employees from soliciting your clients, but it won't be lawful to prevent your former employees who are earning under that high income threshold from working for a competitor business. Now, those types of restraints were the most difficult to enforce in courts anyway, because as we say, courts don't like restricting people from earning a living.
Yep. Okay. Right. Well, look, let's do a little bit of a wrap up here. Let's give the listeners a few key takeaways in a final overview. You know, what's something that businesses should be doing when they think about these issues, Matt?
So, Mark, I think the first and foremost thing is if people want to go away and action something immediately, go and check that your documents are actually signed. Make sure that you've kept records of what it is that you're seeking to enforce, because acceptance by conduct or performance will only get you so far. So your best evidence is documentary evidence. That would be the first and most critical action item.
And just on that, I mean, that's a theme that's come up in these discussions time and time again.
Yeah, correct.
And it's really basic, and it is really basic.
It is really basic.
Make sure your documentation is in order.
Correct. And it seems like something that would be a given until it's not, and it's usually at the point in time where you're seeking to enforce and you've got a problem that you stumble upon, oh, I've made an oopsie. And so I think that concept is probably the first and foremost. The second most important concept to take away today is to actually invest some time and effort into tailoring clauses for purpose. With the rise of AI and ChatGPT, what I'm starting to see a little bit more of now is people who are or think to be fairly sophisticated working through contracts and documents by themselves. Notwithstanding that AI plays a purpose and it's got some benefits, I would like to think that when it comes to drafting specific clauses, that human expertise will always outperform artificial intelligence. So I think that if you spend that little bit of extra effort and that little bit of extra time in making sure that you've got clauses that are fit for purpose and you're aligning the purpose of the clause with the actual person and their role, then you're typically going to be putting yourself in a far more favourable position. If you want to apply blankets and you want to have unlimited scopes and jurisdiction levels and time periods, you're inevitably going to be on the receiving end of an adverse response if you want to take this to a court.
Okay, that's great. Well, it's some really useful takeaways there. Matt, thanks very much for your time.
Thanks, Mark.
And Elizabeth.
Thanks, Mark.
Good discussion. And listeners, if you want to get more detail on this, I'm sure you can call Elizabeth or Matt or the team at Pragma Lawyers, and they can give you even more detail if you need it. Thanks for listening.